Criminal Justice, Mainstream and Cross Currents, Chapter 6, Policing and the Law. This is a narrated version of this PowerPoint presentation. Policing and the Law. The individual police officer makes dozens of decisions each day that consider the rights of offenders, the opinions of citizens, the demands of supervisors, peer pressures from fellow officers, legal statutes, and the officer's own judgment. Discretion is at the core of the police officer's occupation. What we expect from the police. The police must develop an occupational culture that shapes their response to the crime, offenders, and the criminal justice system. Manning. The police have the task of crime prevention, crime detection, the apprehension of criminal suspects in an efficient, apolitical, and professional manner. Figure 6.1 illustrates contact with the police and can be found with your textbook. Of the 40 million people aged 16 or older reporting face-to-face contact with the police during 2008, 1.9% experienced the use of threat or force. How the police work: watchman style, legalistic style, and service style. The watchman style distinguishes between two mandates of policing: order maintenance and law enforcement. It involves discretion, and preserving the social order is key. Legalistic style concentrates on enforcing the law by writing more tickets, making more arrests, and encouraging victims to sign complaints. Requires little discretion. The service style, concerned with service to the community and citizens, employs alternative strategies, official warnings, or diversion programs. Discretion is used, but subject to formal review and evaluation. The quasi-military nature of police organizations. According to Bittner, there are 3 reasons the military model is attractive to police planners. 1. Both the military and the police are in the business of using force. 2. The introduction of military-like discipline in the 1950s professionalized police departments. And 3. The police lacked other models of organization. The major difference between military organization and the police is discretion. The difference between the police and military also includes military, important decisions are made at the top of the chain of command, and with policing, discretion is vested with the individual police officer. What the police do: patrol, investigation, traffic enforcement, peacekeeping, and order maintenance. Patrol, used to deter crime, enhance feelings of public safety, and make officers available for service. 4 aspects of response time for patrol: discovery time, reporting time, processing time, and travel time. Investigation. Detective takes over evidence gathering so the patrol officers can resume patrol. Photographers, crime scene technicians, and others help detectives investigate a case. Traffic enforcement. Respond to accidents, detect drunk drivers, apprehend suspects, enforce traffic laws. Traffic duties most often bring police officers into close contact with citizens. Figure 6.2, Reasons for Contact with the Police. This figure is available in your textbook. The most common reasons for contact with police in 2008 was being a driver in a traffic stop. Other reasons: residents suspected, police investigation, police provided service, reported problem, traffic accident, and passenger during traffic stop were the other reported reasons. Peacemaking and order maintenance includes domestic disputes, crowd control, vice, mental illness, juveniles, and first response. The rules the police follow include: 1. Procedural law, rules for the government. 2. Does this tie the hands of the police? And 3. The underlying values incorporated in the Constitution must be met. Police discretion. The police do not make an arrest every time they are authorized to do so. The criminal justice system could not effectively deal with so many cases. The most serious offenders would be obscured by the mass of cases. Pros for police discretion. Selective enforcement may result in less overall crime and less damage to citizens and property. Cons include violates the idea of fair play and all suspects are not treated equally, and it depends on the specific type of discretion. The Fourth Amendment. Procedural law controlling the activities of law enforcement is derived from the Fourth Amendment. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized. Even though it constitutes only one sentence, the Fourth Amendment covers a lot of territory, including search, special needs searches, seizures, stop and frisk, and arrest. The Fourth Amendment includes the trespass doctrine, privacy doctrine, plain view doctrine, open field doctrine, public places, and abandoned properties. Search. Officers must have the approval of a judge to get a search warrant. However, the court recognizes four major exceptions to the requirement that officers obtain warrants before conducting a search. These include searches incident to the arrest, consent searches, exigent circumstances, searches or emergency searches, and vehicle searches. Special needs searches include inventory searches, border searches, airport searches, searches of prisoners, searches of probationers and parolees, searches of students, and employee drug testing. Seizures. The Fourth Amendment does not allow illegally seized evidence to be presented in court. If the police intimidate a suspect so that he or she does not feel free to leave, an illegal seizure may be deemed under the Fourth Amendment. Stop and frisk encompasses two distinct behaviors. Stops are seizures, frisks are searches. For a lawful frisk, a stop must meet the condition of a lawful seizure. Stop and frisk continued. Actual seizure stops involve officers physically restricting a person's freedom. Show of authority stops involve officers showing their authority and the suspects submitting. Arrest. A high standard of suspicion of guilt is required. Requires that police have probable cause that the suspect committed a crime. To use deadly force, the officer must believe the suspect to be a threat to others. The court recommends 4 restrictions on home arrest. 1. The crime should be a felony. 2. The police must knock and announce. 3. The arrest should be made in daylight. And 4. The police must meet a stringent probable cause requirement that the suspect is in fact at home. Interrogation and confessions. Individuals have constitutional rights that must be respected in the questioning process. These rights stem from the 5th, 6th, and 14th Amendments. The 5th Amendment is related to self-incrimination, the 6th, right to counsel, and 14th, to due process. Questions from this chapter. Do the police make an arrest every time they are authorized to do so? What is the procedural law controlling the activities of law enforcement derived from? And why is the military model attractive to police planners? This concludes this narrated version of this PowerPoint presentation.